Gregory Freeland, petitioner, Judy Ann Joyce.
I'm here.
This is case number 23-000135. Mr. Freeland, are you here? Ms. Joyce, you are. Is that correct? Yes, I see
Sir.
you. All right. All right, Ms. Joyce, here's the situation as I understand it. There was some sort of a misunderstanding in regards to what your court date was going to be. It was set for the 22nd. You didn't appear until the 30th. An order was entered on the 22nd as a result of your absence from court on that day. You've asked the clerk's office to get you a copy of the, or at least you inquired about getting a copy of the record of court that day, but you didn't make a formal request for that discovery. So that's not available right at this moment. I have not listened to that tape, but the clerk's office staff has, and it does indicate that the hearing was reset for the 22nd. The docket notes reflect that it was reset for the 22nd as well.
But nobody sent me anything. Nobody emailed me. No one sent me by snail mail. No one sent me a redate because the judge said it was going to be on the 30th, the day after the holiday. He said that multiple times. And I gave my email for the clerk to email me the docket for that day or the revised date. Like, no one gave me any of that. So that's not my fault. That's the court's fault.
So here's the option that I'm going to offer to you today. If you wish the court, if you wish the clerk's office to provide you a copy of that tape, you can, or that, the tape of the proceedings that day, you can check that. You can also check the court's notes on the docket as to what was the date that it was to be set. You're still going to be entitled, if you wish, to have a full hearing on this matter. It's just a question of when that's going to be. It's not going to be today because Mr. Freeland is not here. But we can reset that. Here's the other thing. The court does not send email notices to people about what their next court date, especially when they're in court and the court record reflects that it was on the 22nd.
No, sir. I'm sorry. I have a witness on here right now who was in the courtroom and he said on the 30th. And he told me to give my email so the clerk can email me what the information for that day. So why would the judge ask me, the judge that was just here, the other judge that was here before you said. So that you didn't watch the video, but you really need to because it's the judge's fault and the clerk's fault, not my fault. Has nothing to do with me. I was the one.
So I'm giving you the option.
Being harassed.
I'm giving you the option to have this matter reset if you wish.
Of course, that's why I'm here today. That's why. Yeah, that's why I asked for one. It just doesn't make sense. And they want me to pay $20 for the video when it's
July 10.
Yeah, we can set for that.
That's sufficient time to give Mr. Freeland notice that it's going to be reset.
Okay.
I already gave him notice. He refused to answer his door.
Well, all right. So, Ms. Joyce, we're going to reset this matter to July the 10th. Monday, July the 10th.
Perfect.
And that'll be at 9 a.m.
Perfect.
We're all on the same page, right? You've got it for
Yes.
July 10
Yes.
at 9 a.m.
And see, I can even show you, look at my paperwork
Sure.
says
Have to serve him with notice of that.
that I
Do we
wrote
send her
it.
a form?
Yeah,
Yes.
we'll send her
All right.
first.
All right, now listen, Ms. Joyce, we're going to send you a
Yeah.
form for you to serve on Mr. Freeland so he can be in court on that day to contest this hearing.
I sent him one for today. He just didn't show up or didn't want to answer his door for the paperwork.
All right, if he didn't
Mhm.
answer the door, you didn't serve him with it. So
I
that's why he
mailed
doesn't-
it to him. I mailed it to him. He refused to answer the door.
was it certified mail?
Yes, sir. It's in the paperwork. I sent it via email.
Unknown caller.
Sorry. About to kill my phone. Probably not the first time that's happened, right? All right, Ms. Joyce, here's what we're doing today in case number 2300135. Based on your motion to reset this hearing or terminate this hearing, we're going to do that based on, I'm simply going to call it miscommunication of court date. The matter will be reset for a full hearing on the merits, and that date will be July the 10th.
Okay.
The order that was entered on the 22nd is going to remain in effect until that date. I understand your position in regards to the fact that you were not properly advised of what the court date was going to be. It's also my understanding that the court record and the CD of this indicates that it was set for the 22nd and was stated on the record for the 22nd. Again, understand that there's a dispute about that. So we're not going to undo that order that was entered until we have a full hearing on this matter. You're required to make service on Mr. Freeland of the notice that will be sent to you of the court date. And I'm signing that and have signed that today. So questions, Ms. Joyce?
No, sir.
All right, July the 10th at 9 a.m.
Thank you so much.
You can get a copy of this order this afternoon on the website.
Okay. Thank you so much.
Thank you.
There we go. Now this case had been, I'm sorry, this is case number 23-135. All right. This case resulted in the issuance of a anti-harassment order on May 22nd. At that time, the petitioner was present, and apparently the respondent was not. Later on June 2nd, looks like there was a request that the default be set aside, and it looks like that order was granted by Judge Pro Tem Hoffman. According to Judge Pro Tem Hoffman's order, there was some confusion about the court date and the requirement to appear. And
Yeah,
so
because they
he
gave me the
ordered,
wrong date.
Yeah, he ordered a full, the matter be heard on the merits, basically,
Mhm.
but that the temporary order would remain in effect until today, and that sort of brings
Mhm.
us up to where we are now. Okay. All right, so are both the parties ready to proceed?
Yes.
Yes.
Okay, you're ready to go? Okay, thank you. And what I'm going to do here in just a minute is I'm going to swear you both in. I'll let Mr. Freeland go first. Then after I've heard from him, I'll let Ms. Joyce tell her side of it and make a decision on whether the order continues past today. I'm going to ask you to both keep in mind that any material, written statements, anything else that you've submitted as part of this case is already part of the record of the case, and I've seen it and read it. So it's not necessary for you to fully repeat everything that you filed in the case. You can just summarize it or refer me to specific sections of it if you want to emphasize those. Okay. So can I have both of you raise your right hands? And do you both swear that the testimony that you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes,
Yes.
sir.
Okay. All right, Mr. Freeland, you get to go first. Go right ahead, sir.
So first I wanted to point out I was not properly served for this hearing. In her numerous attempts to contact me first, before even filing this with this court, she attempted to have her partner or whoever she lives with, who was previously told not to come on the property, had that person trespass over 6 different times in an attempt to serve legal documents, which the police even pointed out were not valid. And as seen in the evidence I have submitted before this hearing, the emails from the county court clerks actually prove that that is true, that those were not valid documents. And so he did not have a right to be on the property. Other than that, as far as her attempting to serve me by mail, I have seen no request for service by mail submitted to the court and filed in evidence, so I'm unsure if that was even allowed. Regardless of that, the proof of service for the mailing receipts indicates that not all the required documents were served to me. In addition to that, the next time she served me after that, or attempted to, was with another family member, which they have all been told they are not welcome on this property multiple times. And that is missing pages in the filing here. So there is no proof of service here that she has provided today that indicates I was properly served. In addition to this, she has submitted zero evidence to this court and has made numerous claims in order to get a continuance. The first time that she was told the wrong date. In my evidence I've submitted, as well as the audio recording of the initial hearing, that is completely false. At no point was the date that she mentioned ever even spoken of during that first hearing. And in addition to that, the judge said 7 different times when it would be held. She seemed to have enough time during that court hearing to interrupt the judge in order to give her own opinions, but for some reason she was unable to figure out the date there. That seems highly unlikely to me, but it does seem to me that she's committed perjury in order to get this hearing today. I've submitted numerous things in my new evidence, including the fact that she lied multiple times now about when she was initially served. First, during the initial hearing, she was corrected by the judge immediately when she was incorrect about when she was served. And now on this latest filing, she has chosen to submit false information again about when she was served, as proven by not only the photograph, the email, but the affidavit from the process server that I used. She has essentially submitted false information here and used multiple attempts to serve documents in order to harass me again. There is nothing she has submitted here that gives any reason or just cause to negate this order and to strike it down. Everything she has to offer here today would be hearsay at this point, whereas I have submitted numerous forms of evidence showing that she has potentially committed perjury in order to get this hearing and has not properly served me at all. And in addition, I wanted to point out even her service by mail, even if that was allowed by the courts, she submitted a proof of service for it, but that was never actually received at this address as proven by the tracking information I provided. So there is a plethora of false information coming from her side in order to get this hearing today. And I'm requesting that this be denied and the order remain in place, and if possible, extended for this. I believe she needs to face charges for lying to the courts in order to drag me here again with absolutely zero evidence.
All right, Ms. Joyce, you can tell me your side of it. And before you start, I'm going to tell you, you don't need to address the issues of whether this case should be here for a hearing. That decision was already made based on the pleadings by Judge Pro Tem Hoffman. So we are here to address the merits of it, and there's no need to readdress that, because I'm not making a decision here as to whether or not Judge Pro Tem Hoffman made the right decision. The decision I'm making is whether the order remains in place or not. So Ms. Joyce, go right ahead.
Cool. You can give him his order, and you can give me an order against him as well. Okay, that's what I want, and that's what should be happening, because he's falsely accusing me of all these things when I have paperwork and emails from all of the people that work there of all of my stuff. And why would I write down May 30th if the judge didn't tell me May 30th? Okay, but I don't care. Give him his order, keep his order. I have a 12-foot fence or however big it is, so he can stay on his side. He can live his life, continue wearing dresses. I don't give a shit. Like, I'm so mad that he thinks that he can get away with all this stuff. I'm sorry. I'm so mad that he's sitting here saying that I'm a liar.
I want you to stop
I'm not
right
a liar.
there, Ms. Joyce. I
Not
want
a
you to stop
liar.
right there and take a breath. All right, I see where this is going. And this is what I'm going to do. I am going to leave the order in place as issued by Judge Pro Tem Laconin. And then Ms. Joyce, to address the issue that you brought up, which is that you want an order to protect you from Mr. Freeland,
Correct.
that you can petition the court for that order. I can't just make it up at this point. You can file a petition for an anti-harassment order of your own.
I did. I absolutely did. This man has been harassing me, my family, ever since he moved in. He's had my bike stolen out of my yard.
But like I said,
this man has been harassing me. I
Ms.
put in a
Joyce,
petition.
Joyce,
I don't know why you don't have it.
Do you
put
have
in
a
a
case number
petition.
for your petition?
I guess not. I guess they gave me the same case number. I guess they didn't. That's not what they gave me.
Yeah, this case number is Mr. Freeland's
supposed to be-
petition. And if you want a petition, you need to
I've
draft
already
one
done
and
that.
file it for your own case, which you're free to do. You can do that at any
I
time.
will. I most certainly will. So we can miss
Okay,
one.
then my ruling on the issue before the court today is that the order as previously issued will remain in effect.
I have a
that-
question though. Could you ask him a question for me? Because
You know,
I
Miss
need,
Joyce,
I need,
Miss Joyce,
I-
maybe, but you gotta let me finish and not interrupt me, all right?
I didn't
That's-
mean to interrupt you. I'm
Is
sorry.
there another
I'm just-
context where interrupting people who are in the middle of performing their jobs works? That's no different in
No,
court. You
sir.
simply can't do it, okay? So the order will remain in effect. I don't see any reason to overturn the prior order, and it's being issued without objection. And it's going to remain on the same terms and conditions as originally issued, and that addresses the petitioner's request that it be extended. There isn't any basis for that.
Cool.
But I'll remind you, Mr. Freeland, that under the law, you've got the right to petition to extend or renew the order. And that's a process that you can do as the order is about to expire. And I'll just refer you to RCW 7.105 to decide when or if you want to do that. Now, Ms. Joyce, your question.
I need you to ask him how he got my name, my last name, and my boyfriend's name, because I think he did it fraudulently. I think he
can't
did
do
it.
that.
Why not?
That's not the proper role of the court. I'm sorry.
Okay, so he can have, okay, all right. All right. He did it fraudulently, went through my mailbox. So he's harassing me. He's taking video of me and my children. Who's harassing who? From day one. I'm gonna file.
Ms. Joyce, I'm gonna end the hearing here today.
Cool. Thank
You
you.
can file if you choose to do so. That'll end the matter.